Hello everyone, I'm George from Ireland. So this is my English law channel. Continuing with contract law. So today I'm going to be looking at the intention to create legal relations as well as capacity to contract. We know that we have to have an agreement if there's going to be a contract, consensus ad idem, as in there's agree about the same thing, the same subject matter, the same terms. The two parties agree. So we need to have an offer made, and then there must be acceptance. But they must also be intending to create legal relations. It can't be too informal, just social agreements or familial agreements. Usually there's no intention to create legal relations. It wouldn't be justiciable. Otherwise, the courts would rapidly be inundated with the most trifling domestic squabbles. Remember that consideration must have been exchanged. Um, so, about the intention to create legal relations, one of the key cases here is Rose and Frank Company against Compton Brothers, a 1925 case, and Lord Justice Atkin sat on this one. Well, this is what he had to say about it. To create a contract, there must be a common intention of the parties to enter into legal obligations, mutually communicated expressly or impliedly. That's the end of the quotation. They have to say it outright, that's expressly, or it has to be hinted, but nevertheless obvious to a judge or anyone legally trained that they did regard this as a contract which was legally binding. There is a presumption of such an intention to forge legal relations in any agreements between businesses, B2B contracts, and business to business. So in commercial agreements, there's that rebuttable presumption. You'll see it in Bun and Bun against Rees and Parker, 2002, or indeed Bowerman against Association of British Travel Agents Limited in 1996. So remember that presumption is rebuttable. It could be displaced if there is persuasive evidence to the contrary. And you see another relevant case here, Hadley and others against Kemp and another in 1999. And Judge Park sat on that one, where it was possible to rebut the presumption that there was an intention to forge legal relations. So there's an honourable pledge clause, for example, in that Rose and Frank Company against Crompton Brothers, 1925, which I mentioned earlier. You know that things, sometimes they say this is just a gentleman's agreement and therefore it cannot be adjudicated before any court, in which case there is no intention to create legal relations. Now, Licenses Insurance Corporation against Lawson in 1896. The things that were said when people were very flustered or highly emotional in the heat of the moment, that might show that there's no intention to create legal relations. Things that people say jocularly displace any assumption of the intention to create a legally binding relationship, such as in Leonard and PepsiCo, 1999, or indeed Blue against Ashley in 2017. So remember, as I said, in the familial sphere or between some group of friends, if it's in a non-commercial context, then there shan't be any presumption of an intention to create legal relations. Remember, there was Balfour and Balfour, 1919, where the husband was going to the erstwhile Ceylon for a while, we now call it Sri Lanka, and agreed to send his wife, I think it was £30 per month, which was a tidy sum in those days. Bearing in mind, say, the average salary would be something like £100 a year, and the fees for Eton were about £170 a year at the time. So anyhow, then he ceased sending the money. His wife thought this was actionable. She brought him to court, but the court held that there was no intention to make legal relations. Moreover, the wife wasn't giving any consideration in return for the same. Or between a parent and a child, there's usually no such intention. Jones and Padavatan, 1969, where the mother, she purchased a flat in London whilst her daughter was reading for the bar, and the daughter was going to live there gratis until such time as she was called for the bar. The mother changed her mind about it. The daughter took legal action and failed. As a trainee barrister, she ought to know better because it was within the family context. Moreover, the daughter wasn't giving anything for it. No consideration moving from her side. So now this is a rebuttable presumption again within the social or domestic situation. So very strong evidence can rebut the presumption that there is no intention to create legal relations within a family context or in the setting of a group of friends. For instance, Merritt and Merritt, 1970, the husband and the wife, they were already living separately, and so there was some sort of agreement between this estranged couple, and it was in writing. So it was found in this case there was an intention to create legal relations. Now, sometimes there can be mutuality of obligations. Simpkins against Pays, 1955. If they're both giving something, this could show that there is an intention to form legal relations. It was about the football pools. This kind of guessing which football team was going to win. There's a sort of gambling thing, and to share the proceeds of any winnings. So, based on the previous conduct of the parties, it could be found that there was an intention to forge legal relations, such as in Peck and Latto, 1973. So, Edmonds against Lawson, 2000, was another crucial case, and it was heard by the redoubtable Lord Justice Bingham, who subsequently been called to his reward. And he said, whether the parties intended to enter into legally binding relations is an issue to be determined objectively, and not by inquiring into their respective states of mind. The context is all important. Close quotation. So what would a reasonable man believe in the case, not what do the parties themselves believe at the time? Okay, well, let's look into the issue of capacity. How about those who are below the age of 18? Because one doesn't reach legal majority until age 18. So usually a contract signed between a minor and an adult is not binding. So the contract will become binding if someone, having signed it as a child, attains the age of 18 years, and then it is binding. So obviously one attains man's estate, or indeed woman's estate, at 18. It used to be 21 if you look back to 1969. Some of the earlier cases will have legal majority at 21. Even though you could be in full-time work long before that, you could be married, you could have children long before 21, especially in the old days. Now, there are exceptions where a contract shall be binding upon someone who's under 18 at the time. So someone who purchases necessaries. Now, what are necessaries? Food, clothing, certain things, but also having regard to his or her situation in life. So diamonds probably wouldn't be a necessary, even if you're very rich. So the Contracts for Necessaries Act, well, you look at the Sale of Goods Act 1969, Section 3.2 and 3, a reasonable price has to be paid. Well, what's reasonable? That is any man's guess. But Nash and Inman, 1908, decided this. Now, if there is a beneficial contract of services, again, this shall be binding upon the minor. For instance, Doyle and White City Stadium, 1935, because that was good for him, working there, or indeed Aylesbury Football Club against Watford Association Football Club, 2000, about some youth footballer, and could he sign a binding contract and could he go from one club to another. Proform Sports Management Limited and Proactive Sports Management Limited is 2006 is another such case about whether the contract of service was actually beneficial to the minor, and that can be binding upon this young person. Okay, so if we carry on, think of mental incapacity, where someone is not compos mentis, a vulnerable adult. So it's an adult who's effectively a child because of his or her egregiously low intelligence. You can be below average intelligence and still mentally an adult. You have to be seriously below. I mean, I don't think they actually put an IQ on it, but it'd be like IQ below 80 or something. So could not comprehend what he or she is doing, having very, very limited lexis and so forth, poor cognitive skills, seriously mentally ill. In this case, the contract might not bind such a person. The Mental Capacity Act of 2005 is about this. A person shall not have capacity to form a contract, and this is the quotation, if unable to make a decision for himself in relation to the matter. Okay, that's the end of the quotation. So it doesn't matter whether the person's impairment of mind, derangement of mind, was just a transient thing or was lifelong. If at the relevant time the person lacked capacity, then non est factum, it is not done. However, under Section 7, they are liable to pay for necessaries because otherwise you couldn't sell them anything. You couldn't sell them food. You couldn't sell them a bus ticket. All right. So we are going to look on to consideration after this. Toodaloo.